Really, we're not normally this disorganized. Danbury Park versus Carmen Donnell.
That's 6817 on behalf of the plaintiff.
This tenant is not.
They have not checked in. All right. Would you like to take a default, sir?
Your Honor, we have a default judgment already in place. This was her motion to set that aside.
Right.
The park manager did ask, or the complex did ask for a brief adjournment because she's new manager. She's going through the file. There was a research certification issue. So she wanted a brief, but she hasn't showed up a few times, so I'll defer to the court of.
You're indicating your client may want this adjourned out, or I don't have a problem doing that if you think that's wise. We have a number of, and the reason I say it so that there's some context, we have a number of complexes where there have been recertification things. So I think it's probably wise to check into it because the number on the judgment, it's a bit high, for a subsidized unit. So how much time would you like?
Well, I was gonna seek a date that's whatever the court schedule allows for, but I'm down here on January 23rd at 9 a.m. for another Danbury case if the court schedule allows for that.
And we're in 23rd. That's a Tuesday.
That's a Tuesday.
Is
It's
it-
a
is it-
civil Tuesday.
It's a civil Tuesday.
Mhm.
Okay. So you're down here in my court on
Yep.
on that Tuesday?
Yep.
Oh, okay. And I don't have a problem doing that. January 23rd,
Thank you, Your Honor.
2024 at what time? 9 a.m. All right, fantastic. Sorry about the wait.
I know it's two errors that they owe to me.
Thank
Thank you. Have a great day.
You too. Calvin Johnson versus Denitra Walker.
Hi, I'm here, Your
Okay.
Honor.
Okay, hold on one moment.
Good morning, Your
Okay,
Honor.
hold on a second. Let me try to deal with this one and then I'll call it back up. So then. All right. Johnson versus Walker.
Good morning, Your Honor. Matthew Bieber on behalf of the plaintiff, Calvin Johnson, who I believe is also present on the Zoom call.
All right. Okay, this is a termination case. And where are the parties on this?
Your Honor, I need for the attorneys to get an attorney because they just went back to school with the veterans clinic that I use on Monday. So I just need a little bit more time so I could get assigned an attorney or find out what's going to happen with David.
Respectfully, Your Honor, if I may, this matter was heard back in December. And at that time, the tenant similarly requested time to seek a hearing. We did consent to a extended adjournment to today's date. My client, this is a simple termination matter. My client wants to sell the property.
Mr. Matthew, do you remember I told the judge that the school wouldn't be back to Monday? That's what I told them. They wouldn't be back in school to Monday the 8th. And then that way they'll call me back and get me assigned. That's why I wanted them to push it out. Remember, I told them they wasn't coming back until that Monday.
If I may, again, my client's position is we agreed to an extended adjournment for the tenant to do this. She agreed to today's date, stating at the time that was enough time for it. And so for that reason, I'm simply, I would object to any further adjournment, but I leave the matter in the court's discretion.
Okay, and I don't know if you were involved in the other hearing, counsel, but previous cases, Ms. Walker, you were represented by the Veterans Clinic, correct?
Yes, sir. And that's what I tried to explain when we had the case in December, that the school didn't open back up until this Monday, but the judge made it this Friday, and I haven't heard back yet if he's going to reassign or what's going on, sir.
Okay. it,
Yeah, sounds good. All right.
all right, and I understand plaintiff's objection. I will also indicate, counsel, and again, you weren't involved in it. I think there have been 2 or 3 other cases filed between these two that have taken a significant amount of time on this. And so I'm aware that there are some other issues which might be present in this case that would not typically be involved in a termination case. Because my understanding is there is no lease. Is that correct?
That's correct, Your Honor. That's correct.
Is that your position, Ms. Walker? There's no lease?
Your Honor, how we had the first lease, it was set up as a normal lease. And then Mr. Johnson and I did paperwork as like a lease to own to buy the property. But once he
Yeah,
got mad, it kind of switched around. So it became complicated, sir.
Yeah.
Your Honor, plaintiff's position simply is that any prior written lease agreements have long since expired regardless of their character. And we're just simply, this is a month-to-month legally at this point, and we're simply seeking possession.
I mean, and ultimately you might be right, counsel, but here's what I'm gonna do. Ms. Walker, you have told, I just want to make sure I'm understanding it. You have contacted the Veterans Clinic.
Yes, sir. I contacted, I left the message at Veterans, and I also just left one with the legal aid just in case something went wrong. But yes, sir.
Okay, here's what I'm gonna do. And I realize, and I'm gonna do it over plaintiff's objection, so the record's clear on that. I'm gonna give 1 more week to the 19th, 2024 at 10 a.m. And Ms. Walker, what I want you to understand is that absent something else, but it would be the court's intent that I'm not going to just adjourn this thing out again. I'm giving you a week. I realize the students, you're right, the students are coming back and the like, and so the contact may not have happened, but I'm giving you that week to at least try to get representation.
Your Honor, can I ask you one question if you don't mind, or do you want me to be
No,
quiet?
go ahead.
Okay, you're saying a week, and let's say they just call me back Monday, because I'm not a lawyer, so I don't understand all of this.
George Birch would ask you.
Yeah, exactly.
I didn't hear you, sir. I'm sorry.
No, I didn't say anything. I think it was some background at plaintiff's counsel. It's okay. Go ahead.
Apologies, Your Honor.
Okay,
No, it's
because
okay.
so I don't know if the people that'll be assigned would have everything, or if I have to start all over showing with all the other paperwork. That's why I don't understand. It's a week. Is there any way it could be 2 weeks in case he give me new students and they won't know me or anything if the students is graduated? That's what I'm afraid.
Okay.
Your Honor,
I understand what you're saying, Ms. Walker. I'm not giving 2 weeks because it's going to be, if they're going to represent you, and they should have your previous paperwork at minimum.
Yes.
If they're going to represent you, then certainly I'm going to make sure that both sides can be prepared regarding a case.
Okay.
But
Okay. I
at this
understand
point-
now.
Okay, because and I want to be clear, at this point, Judge Barr gave a 2-week adjournment because of the students. I get it. I'm giving 1 more week, but I'm not going to hear that they can't be here. Because it may be a different circumstance. If they show up, they have the previous paperwork, but we need to do X, Your Honor. Okay, maybe that's a different circumstance. But if nobody shows up, I'm going to let plaintiff proceed.
Yes, sir.
And if I may, as I said at the last hearing, all my contact information, I mean, any attorney knows how to get a hold of me, obviously, and I'm happy to work something out outside the court absent a hearing.
I understand. All
And
right.
that's what I'm trying to do, Mr. Matthew. That's why I want the attorneys, so I'll know who would be able to call you, because now I have your information to give them.
Everybody can communicate with each other. We'll be good. I'll see everybody in a week. Thank you.
All right. Thank you very much, Your Honor. Go blue.
Thank you. Yes. Thank
No,
you.
You know I'm a terrapin. You just did that to get under my skin. But
Your
yeah,
Honor,
go.
maybe a little bit. It's been a while before I've physically been in for you, but I do. All right.
All right. Take care.
Have a good weekend, everyone.
You do the same. You know, that's the second day in a row that somebody's rubbing this Michigan thing at me. It's okay. I grew up in Ann Arbor, so I like Michigan, but you know, I'm still a terrapin. Danbury Park, recall Danbury Park versus Donnell. Hello, Miss Donnell. We did not know that you were out there.
Yes, Your Honor. I was locked out. I couldn't get in. I apologize.
Oh, is the door?
I thought I'm confused what happened. Yeah.
Okay, well, we're sorry about that if that were our fault. Counsel explained to you what we did.
Yes, I was supposed to contact a new regional manager.
Okay, so he gave you some information to contact someone.
I want to put on record that I have been trying to contact Danbury, but unsuccessful. I have assistants, people that's willing to help, but they can't help me because I have no contact information to give them, but I do now.
Okay, when you're saying assistance.
As far as Hawk,
Okay.
They can't help because they can't get any documents because I can't get to.
No, I hear you. I just want to make sure we're covering everything. So you've contacted Hawk.
I've been in contact with.
Okay, and what have they said to you?
Well,
Well, let me ask you this. Did they say that they would be able to assist you, but they need the other stuff?
yes, they need the document. They need more paperwork. And then the fact that I recertified, I need copies of the recertification, in which I can't get because I can't.
Got it. Okay, and
It's just paperwork that's needed that's in that.
no, I got it. Let me ask you this. Did they indicate like how much assistance you might be able to get?
It's been a while, but she did say, thinking around 4,000.
Okay, so,
But I haven't talked to Hawk in so long because
okay, here's what you need to do. Amy. Hey, Amy's here.
Your Honor, good morning. I apologize for not being there in person.
Oh, it's okay.
I can appreciate
okay.
the accommodation. If I may, to Ms. Donnell, Ms. Donnell, your caseworker, Alicia, has not been able to work on your case since November due to non-responsiveness. I would recommend that you reach out today if you can to inquire about what, if anything, can be done about the status. That's one. And the second would be that assistance wouldn't be able to go beyond 2,000 at the moment. So those are two issues that you need to revisit if you're still relying on Hawk assistance. I'm not sure how much you're owing, but if it is.
And that's part of the problem.
Yes.
This is, Amy, it's a recertification issue. And I'll put it that way only because the number is actually about 7,200 as of July. But
And I have
that's awfully high.
I have paperwork showing it's 4,000.
As of when?
Who's
When
the
I-
issuer of the voucher, if I may?
Pardon?
Who issues the voucher? RPI, CMA, or Ann Arbor Housing?
Who's your voucher?
Voucher?
Do you? Yeah, you have Section 8?
HUD, no, sir.
Oh, it's through HUD?
Yeah, it's HUD subsidized.
Oh, it's a HUD subsidized unit, but you don't know who administers it.
No,
Okay.
I do not. But when I was summoned to come to court, it said 4,000. I should have brought the document with me, but I could bring that. But that's the only document that I have showing. And then after that, I started seeing it go up. Like every month it was going up to now
Okay.
it stopped.
All right. So here's the thing. Let's do it this way. I put this out to the 23rd. I don't know how much we're going to be able to get accomplished on that day, but we'll see where we are. You need to get in. What's the name of the worker for her?
Alicia, but at this point, it looks like she's closed it. So you want to just call back into Hawk. But if you still have her outreach from Alicia, like through an email, I'd recommend that you respond back to that email.
I'm sorry, I didn't understand.
Go ahead. Can you say that again?
Of course. So Alicia Sykes was your assigned caseworker. If you have any like emails or anything from her, if you could find that and respond back to her saying that you are still in need. I'm not sure why you weren't able to complete communication with her.
Well, she couldn't get any paperwork she couldn't get any, she needed to contact someone from that office, from Danbury.
Right.
Because
Okay. I think, Amy, what occurred, and counsel can correct me if I'm wrong, there may have been a change in management and other things that occurred so that certain things didn't go through.
Okay. That happens, and that's understood.
So what we'll do, so you need to find an email. Are you going to be able to do that, Mr. Nell? For Alicia?
Oh, yes, I have her cell phone.
Okay.
Well.
So what Amy's telling you to do is to respond to that email to her so we can try to get that back on track. It may work, it may not, but at least get that back on track.
Okay. So you're saying get in contact with Alicia
Right.
and see if they can still.
Right, because what has happened is your case with Hawk has closed. So it needs to be, if it can be, reopened. But also the other issue, and Amy, you can correct me if I'm wrong, is that the amount you might have been expecting, that amount is lowered. Only because of what might be available funding.
Okay, see.
Okay, but it's okay. But then, so that's what you have to do because of that. But also then plaintiffs they've got things that they have to sort out and try to figure out where you are on this. And they're trying to take a look at it.
Okay.
Okay. And then we'll see the 23rd at 9.
Okay.
All right.
Thank you. So is that Zoom? Or
pardon? If somebody files a Zoom request, we can do it by Zoom. I think counsel's going to be here in any event, but if you want to do it by Zoom, there's a form that you'll need to fill out.
Oh, okay. I mean, whichever.
Okay.
Wonderful.
It's up to you. Thank you, counsel.
Thank you very much.
That's it for that block. And so we'll have to wait till the next block. Court stands in recess. You may be seated. Good morning. Apologize about the delay. Arbor One versus Daniel Robinson.
Morning, Your Honor. For the record, Lawrence Krefman standing in for Cheryl Luckoff on behalf of the plaintiff.
Your name, sir?
Daniel Robinson.
All right, where are we on this case now?
Well, Mr. Robinson is in a new unit. He signed a new lease, as I understand it, and there's an issue about 3 months rent, and there's assistance pending. And Mr. Robinson has applied for assistance working with Hawk, and we're waiting for
Something on that.
So
just so that I'm clear, the 3 months rent, is that like a compromised figure from what was owed, or?
not yet. It's not, so far it hasn't been compromised.
The apartment was condemned at the end of November. I think it's August through November rent I owe. And I'm seeking an abatement because the
Right, thank you, because that's what I was wondering. So that 3 month period is that period you owed prior to the condemnation?
Right.
of the unit. Got it. And, okay, so guess my next question is how's that number going to be arrived at?
Well, I would ask Ms. Luckoff that, but
Okay,
I don't know. We made a proposal at one point, apparently was rejected or not responded to, one or the other. If he's still
Yeah, I
thinking
think
about
they offered to pay half of it or let me pay half of it. But I thought I was entitled to the full abatement. I don't know what's involved with,
okay, so maybe I can give some guidance as to how the court would proceed with something like that. I think, and I said this before, if a unit, unless a wall falls off or some catastrophe happens, it's typically not a circumstance where the condemnation or what causes that happens like all at once. So something like this, I think it was mold and other things that
yeah, I had
Right.
complained months earlier. Yeah.
that's going to be, for lack of a better term, sort of a process. Right. So at some point, the unit becomes uninhabitable, but sometime prior to that point, it's habitable. All right. Maybe not fully, maybe not what you want to be in, but at least it's habitable. So, what you said, August through November, or August, September,
it's
October.
actually August isn't included. He was
Oh, it's September,
September,
October.
October, November.
Oh.
So, and I'm not saying that this is where the court would be. So that in August, that unit might be 75% habitable. Next month, because the same thing is occurring and not taken care of, it's really at 50%.
It's getting worse. Yes.
And then it's getting worse, it's at 25%. And then when somebody comes and looks at it, nobody should be here. So to the extent you can use that sort of analysis, that's the analysis that I would be going through. What was this place in September, kind of thing. So I don't know that helps you. May help you with your guess as to what the court would do, but I think it can be worked out. But it's likely to be sort of the sliding thing that all of a sudden gets to that point. Real question is how fast is that thing sliding? And I don't know that it'd necessarily be a guess on my part, but it'd just be based on my experience in terms of how I deal with that. Okay. So I hope that helps and or confuses things beyond the point of help. Where do we need to set a new date then to
That's
try
what we're suggesting, Your Honor.
All right. Should we, since I guess the posture of the case is you're in a new unit, so you're good in terms of going forward, and we're really talking about this period in time. It seems to me I just set it for a final settlement conference. And then that way, Ms. Luckoff can be here. We can have the parties here and just try to negotiate something and try to get it done. How's that sound?
Sounds reasonable.
And I know you don't know Ms. Luckoff's schedule, but what's my first February date?
Tuesday, February 6th.
Okay, would February 6th work for you?
Yes.
Okay. So I set a final settlement conference, February 6th, 2024 at 9 a.m. in person. All right.
Thank you, Your Honor.
Thank you. And when you, on that day, make sure to bring all of the paperwork that you received from the health department, the city.
when they condemned it?
Yes.
Oh, okay.
Okay, or yeah, whatever you have.
Oh.
As I talk with the parties, that will help me try to figure
A
out.
letter from the city.
Okay. All right, thank you.
Thank you, Your Honor.
Thank you, Judge.
Harbor One versus Ashley Grisham.
Morning, Your Honor. Lawrence Krefman standing in for Cheryl Luckoff on behalf of the plaintiff.
Happened here.
So it's plaintiff or defendant's motion to set aside a default judgment.
Okay,
And
I gotta have these files.
I don't know if there was any extra papers filed with attachments to the motion, but I don't see her grounds for the motion.
All right. Defendant having failed to appear in the court, having reviewed the motion. Court does not believe that the defendant has stated good cause nor meritorious defense of the claim. Defendant's motion for her failure to appear, and based on the substance of the motion is denied.
Thank you, Your Honor.
Thank you. Oh, there's 2 dismissals. I like that. Okay, Harbor One versus Claromino, that matter is dismissed, and Six Trails versus Corral. Carrie Corral. Yeah, that matter is dismissed. All right.
Thank you, Your
All set. Thank you. Have a great weekend. It's at 14A stands in recess.
Listen, you threw me off showing up yesterday. What'd you say?
I got here for, at what, 10 yesterday? Can't remember. No, 9. How late did it go?
I can tell you I had conferences for my kids at 5 o'clock.
Welcome to the 14A District Court. I'm the Honorable Judge Simpson.
That's not right.
This is Mr. Freeman. Court does call the case of Barnes and Barnes versus Danny Johnson and Khalil Love.
Ellis Friedman, Your Honor, for the plaintiff.
Your name?
Danny Johnson.
Okay. All right. And where are we on this case? This is his motion to set aside default.
Yes.
Sir, what's your basis for setting aside this judgment?
I wanted to buy myself a little bit more time because the unfortunate events that unfolded during the time of this old rent problem, probably not on file, but it's something else I'm handling separately. But there was another person paying and they left because they didn't feel the need to, I guess, handle the responsibility that they had there with the apartment. And in the midst of them doing whatever they were doing, I was paying for my half and their half at a time in the process of me looking for a job. Then the last time we were here, I think right before Christmas, is when I had got a job at the pharmacy. And then I just recently got another job as a caretaker. And I'm about to have a third one as another part-time caretaker. But in the midst of all of this, every bit of what I'm gonna get from each job is, coming by the 3-week basis because they're bi-weekly jobs. So in turn, I'm just trying to buy some more time in hopes maybe I can get some type of.
Well, did you talk to the landlord about that, or?
No, I hadn't.
What's the landlord's position, Mr. Freeman?
Well,
No.
it's getting, since the default judgment was entered, there's more rent accrued. So it's really, this balance has gone up by about $800. Double. So.
Did you pay any, you talk about these jobs, were you paying the landlord?
Before, I believe the date that I was here the last time, right before Christmas, I literally was paying on it, but as I paid, as I paid, like, if I were to put 500 down, next thing you know, there's 1,100 more. And then there's a double fee because she left. So anything she didn't pay her late fee, doubled onto my late fee. So it was just accumulating too quickly. and there was no way to pause it to at least let me catch up. So,
Well, that's because you click into another month.
yeah, and then it just doubles, so it's like, yeah.
Well, in order to set aside the default, I have to have good cause for your failure to appear. But I have to have two things, good cause for your failure to appear, as well as you have to put forth to me a meritorious defense. Meaning you have to have some defense to the claimed amount, right? And the problem here, sir, is that even if I considered you working as good cause for not appearing, which maybe is true, there's no defense to this action. I mean, I get that you fell behind. And it might be one thing if you were paying to the landlord more money and at least keeping it at the $2,043. Then if you were at least keeping that at that level, then things can begin to potentially work their way out. Here, what's going to happen is, here, Mr. Friedman just indicated you're up by $800. And, you haven't told me, and maybe I didn't ask, but, within the next 15 days, well, thereabouts, you're going to be clicking in another month. And you told me that you're putting money toward it, but you haven't told me that, I'm going to be able to pay my rent, get that 800 paid, and then I'm just looking at the judgment. So go ahead. You were going to say something?
Yeah, I was asking for is there some type of rent assistance? If there isn't, then I accept my judgment, because at the end of the day, I mean.
You have what?
I said, at the end of the day, I accept my judgment if there's no rent assistance, because it's plain and simple. I don't have the money. I'm in somebody else's property.
You might.
There's no fight about nothing like that.
Right. You may want to call Hawk. They were on the thing. It's 961-1999 and see if there's some emergency assistance available. But I can't hold this. Can't do anything about it.
I won't ask for it I'll give him a week or so, Your Honor.
Actually, one has been filed.
Yeah.
Was it 10 days from when it was filed? So the 13th?
I had not signed it because of the motion, but a writ was filed with the court.
If you want to hang out to it for a week, see if he gets anything, Your Honor, it's fine with me.
Sure, we got that. Okay. So motion to set aside is denied. All right. Contact Hawk. Did you need me to write? You need somebody to put that number down.
I'm misunderstanding. I thought it was a paper here that I could have filled out, but
That's right.
Yeah, for Hawk.
Is that a week? Yeah.
Thank you, Mr. Britton. It was good but strange seeing you on the criminal back in the head.
Yeah, it's pretty much friends of friends and stuff like that.
Yeah.
Kids of friends.
That's what I figured. I said
That's the kind of thing. I'm not really in the market, but I can still handle a drunk driving.
well, it was funny because Ann said that was just weird. I mean, it was like the old days because you were there, Andy was there. It was just
Mike?
Yeah, Mike.
Mike looks like shit.
We just what?
Mike looks like shit.
Mike? Oh, we're still on.
Yeah.
Oh.
Sorry.
Yeah, I thought he looked good. He's just gonna keep trooping.
It was like somebody else.
Yeah.
There's quite a turnover. Prosecutor's office last couple weeks.
Yes, can we go off for a second?
Oh, we're still on.
And I'm on. All righty. Court does call the case of Arbor Woods versus Kiara Morris.
Good morning, Your Honor. Rachel Dornbush, Pellets Law, on behalf of the plaintiff.
All right. And your name, ma'am?
Carol Morris.
And Ms. Morris is here present in the courtroom. This is your motion to set aside.
Yes.
Is that correct?
Yes,
Okay,
sir.
well, what's your basis to set aside?
So I misunderstood the last time we had court, and I thought that I needed to make the payment that morning, and we had court at 2. So I got on Zoom at 2. I did make the payment, the $659 that I told you I was gonna make. But when we at 2:00, they told me to get off Zoom because it wasn't my time and I had missed court. So I do apologize, and that was my fault because I misunderstood. But since then, as like I did put on my motion, I did follow through and make another $659 payment. So that should have taken care of what I was actually brought to court for. And it's just the back and forth with the office. The last time we were in court, they never informed myself or their attorney that they weren't going to allow me to sign my lease. So I've been getting charged that extra month to month since the last time I was in court in April. And we were also told that I was going to be put on this payment plan that they were doing for their tenant. And the help, the resources that I ended up getting, and also the money that I turned in myself, I had a credit with them. So I didn't have to start paying them rent actually until August. So when I went into the office and I talked to, I think her name is Chloe. I think it's Chloe. When I went in the office and talked to her online, if you don't pay by, I think like the 4th or the 5th day, they add on the following month's water and trash. So I was confused. So I'm like, okay, well, why is this being added on? So she explained that to me, and I'm like, okay, well, I need to sign a lease because I can't afford the month to month.
Okay, how much is currently owing?
Your Honor, the current balance with January is $870.18. But if I could respond to just a couple of those things.
Yeah.
As far as the water sewer charges go, Ms. Morris is correct. They do get added on, but they're mid-month and they're not due until the 1st of the next month. So they do get put on the ledger, but the due date and the date on the ledger says, like, for example, if the water sewer for February got added on, it would say 2/1 on the ledger.
Got it.
It does not get added on or included in January's balance. It would be due on February 1st. Number one. Number two, Ms. Morris is correct. She did make a $670 payment on December 22nd. And then there were a few different payments. There's a money order for $105, a money order for $500, and a money order for $659. They're on the ledger for 1/3. In talking to my client, I believe some of those money orders were dated, either 1 or 2 was dated on 12/29, and then either 1 or 2 dated on January 1st. So there was still potentially some monies that rolled over from December. $26. She's technically speaking $26.36 short of the judgment amount that was entered based on the payments that she made. But because it wasn't paid in full in December, by the time those payments that cured the judgment were made, January was then due. So now, in essence, we're here for January. That's what's still due and owing.
Okay.
Can I say something?
Go ahead.
Okay, so she is right that is how it reflects on the ledger. But when you decide to pay online with Arbor Woods, if you don't pay that by the 4th of the month, they add that payment program that they use, it adds the following month to your total. And when you pay with a money order, they charge you $10 to pay with a money order. So it's hard to not have a balance if you're already behind. And I have been in contact with the manager about if we can reverse some of those month-to-month fees, because they're now telling me again that I'm getting charged again a month-to-month fee for January. And I asked him, I said, well, can I sign my lease? And he said, well, no, because we only allow you to sign your lease 90 days before, but I've been month to month since my first year living there.
Okay, just listen. Here's what I'm looking at, and what Ms. Dornbush is saying is January's rent. Right, you were about $26 short of paying out the judgment. January's rent is now due, right?
Yes, sir.
The 840 and some change. When are you gonna have that?
I just recently went back to work Tuesday, so I'm paid every week. I can make another $500 payment on Wednesday, this coming Wednesday.
The
And-
17th?
Yes, sir, and I can have the remaining balance paid in full the following Wednesday. It will be after the office closed because I work 10-hour shifts, so I don't get off of work until 8
So
p.m.
then you would have the balance paid by the 26th. Well, it would really be the 28th of January.
Yes, in full. But my issue with this is I'm still getting charges month-to-month fee.
No, I know,
okay,
but you're gonna get charged a month-to-month fee. You know, I can't force a landlord to sign a lease, okay? And most landlords, they're not even gonna look at you to sign a lease until you get your balance paid.
No, I understand that, but they're telling me now that, because that's why I asked if I could sign for January. He told me like, well, you have to wait 90 days before the last lease you sign. So I just asked, well, can I get that in writing? Because I have a meeting with Hawk on the 22nd, and I was diagnosed with cervical cancer earlier this year. So I have been off of work a lot. So from me trying to get help from even family, friends, or an agency, they're asking me, well, why are you not in the lease, or why are these certain charges coming up? That $39 doesn't seem like a lot to some people, but
I hear you.
Yeah,
It's
so
just, they're not going to, nor am I going to try to cajole the landlord to give you a lease until you get this balance paid. And I understand that they may have a waiting period to see if you're gonna pay before they're gonna give you a lease. I get all of that. There's not a whole lot I can do about this.
I'm sorry. I understand what you're saying. It's just, I think the last time I was here in April, I left here with a credit and I didn't have to pay rent until August. So my question to the office is, why did y'all not let me sign the lease then? Because I could have avoided these extra charges that I'm dealing with now. And I had surgery August 8th, and that took me out of work for almost 2 months. So I'm going to pay my bills because I don't have the luxury of renting a home from them. I just rent the land. So I still have a mortgage company, and I don't have kids. So it's not a lot of help when you single with no dependents. So I understand, but I just feel like we're going to be here again if.
I know.
Okay.
I hear you.
I'm sorry.
All right.
I'm just trying to.
I know you are, and there's not a whole lot I can
I
do about
understand.
it. Okay, I mean, I hear you, but what I want to do, irrespective of the lease issue, and you and the landlord can try to see what can be worked out about that, is to get you paid. I mean, because what I'm looking at here, and I know over the objection of plaintiff, I'm going to give you an opportunity to get this January clear, because the only thing that would happen is if you paid another $27, you would have paid off this judgment. And then when you talk about added fees, they're going to file again. And then you're going to have court costs. Okay, so it's just going to be more that's going to ultimately get added on. You follow me?
I understand. Are court costs included in that past due balance that I
Yes,
just had?
everything should have been included. So what I'm trying to do is do it in a way that you get paid, try to square yourself for January.
Okay.
And then not get another, whatever court costs were on this case.
And Your Honor, maybe to the court's surprise, I don't have an objection to the court giving Ms. Morris an opportunity to get the current balance paid up. Although I think Your Honor may have been looking at the February calendar and referencing the 28th.
Right.
I show if she's able to make a payment on the 17th, and then the remaining balance, I think she said on the 24th, which is the following Wednesday. Is that correct? Ms.
Right.
Morris?
Wednesday and Wednesday.
Oh, okay.
Yeah, the
Okay.
28th is a Sunday. That's the only reason why it stood out as maybe being
No,
off.
I don't think I was looking at February. What I did is I went the 17th to the 26th, which was that Friday.
Gotcha.
Okay. So here's what I'll do. You're gonna pay 500 on the 17th. And then you're gonna pay the balance on the 24th.
Yes, but I'm gonna pay that 26 and whatever the change is. Can I get that number again? I'm paying that today. I appreciate her, but Arbor Woods has been through, since I've been there in 2020, they have been through 6 different managers. And I'm just like,
Okay.
It's 26.36, Judge, from Ms. Morris's budget.
26.36.
36 cents said that would satisfy the judgment amount that was entered last month.
Okay.
so plus $10.
Just pay him $27.
I'm gonna pay the extra $10 because it's gonna
Okay.
be $10 charge
Okay.
for the money you're.
Do it. All right, that's fine. All right, so do that. And then I'm going to adjourn this out. I have the 26th, right?
Yes.
So I'm gonna adjourn you out 2 weeks. Get this done. Okay? And ultimately, I know you're unhappy with the month-to-month fee, but if we do it this way, this actually saves you money. Okay, because you won't have those added court costs.
Okay,
Okay?
okay.
Why are you looking at me like you don't believe me?
I do believe.
Did you see that look?
I do believe.
No,
but you
I
know
said that. And she looked at me like,
when I was 716, when that little building was up there, you told me, I came to court for MDOP, and you told me black and white means everything. Paper trail means everything. So when I go to that office, I say, well, if I can't sign my lease, can I get it in writing?
oh, so you're gonna.
So
No.
I learned from the
Now,
best. Paper trail is everything. So I just need it in black and white. I can't sign
You're gonna throw up something I told you about 15, 20 years ago.
and it stuck with me. And
It
I
did?
swear, and when I come into a courtroom, when they don't have that black and white, I walk out. Good to go. So I thank you for that. And I tell everybody that. A lot of people, well, Judge Simpson is Judge Simpson. I like Judge Simpson because he go by the book.
I do. Okay,
But I
do the right
appreciate
thing.
you, and I appreciate the attorney as well. I really do.
Oh,
Thank you.
okay. So what we'll do is we'll see you on January 26th, 2024 at 1 p.m. Okay, get that paid.
I will.
All right.
Sorry, Judge, what was that time on the 26th?
1 p.m.
1 p.m. Thank you.
All right. Take care of yourself.
I will. Thank you.
All right. Did you see that, book? It was like hurting my feelings. Court does call the case of Arbor Woods versus Carl Hogan and Amber Richmond.
And for the record, Your Honor, Rachel Dornbush, Palace Law, on behalf of plaintiff.
Yeah, one person signed in. Hello.
It's Mr. Hogan.
Say your name again.
Carl Hogan.
Okay, Mr. Hogan. All right, this is your motion to set aside default.
Yes, I missed the court date. I was used to coming. I think it was in the afternoon, and then I had a morning court date, and I just forgot. And I went to work, and I called up to the courtroom to verify, and she said, yeah, it was earlier. So I came in that same day to set the motion aside so I can get everything paid off because I knew I would be able to.
Okay, so you know what? Can I see that last file real quick? Because we may hang on a second, Mr. Hogan. I just want to make sure. Oh, she didn't. I don't know why. Okay. Okay, Mr. Hogan.
Yes.
Your Honor, I just had a thought, and maybe that's what Your Honor was looking at. Did Ms. Morris pay money into escrow?
He sure did.
Okay. Do you know how much off? Do you recall if that's what you were just looking at in the file?
It's he paid $1,300.
Ms. Morris did or Mr. Hogan did?
Hold on. No, Mr. Morris. No. Which one were you asking me about?
Sorry, I know you would pull back Ms. Morris's file, and I was wondering maybe you were looking for escrow in that case.
Yeah, I was, and I don't. Hold on. Let me see. 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 Let I don't see escrow in her case.
Okay, but Mr. Hogan did pay $1,300 in escrow?
Yes, he did,
Okay,
which is 72 short
of the judgment amount. But, Your Honor, is only $29.81 short of what's currently due. So, Your Honor, Mr. Hogan, Ms. Richmond did make some payments following court. There was a $700 payment on the ledger as of December 22nd, which is the day the judgment entered. And there are payments on the ledger of January 3rd for $20, $223, and $500, so $743. My client informs me that 2 of those 3 money orders totaling $723 were paid on were purchased on December 29th, and the $20 money order was purchased on January 2nd. The office was closed on the 2nd, so they didn't get them until the 3rd. But based on that, the defendants did purchase money orders sufficient to cure the remaining judgment amount before the end of the year. Obviously, we have a balance due right now for January, and that's the $1,329.81. I would propose, Your Honor, and if Mr. Hogan is in agreement, that we can enter an order that sets aside the judgment, dismisses the case, the $1,300 in escrow gets released to plaintiff, and then defendants just pay up that remaining $29.21. $29.81. I don't have authority to waive that, but if they can get that paid up, that would get them current with the escrow being released to plaintiff.
Got it. You understand that, Mr. Hogan?
Yep, sound like I need to pay $39 to $40.
$39.81 if you want to be specific, if you plan to pay with a money order.
That's exactly what I plan to do today.
You're gonna do it today? Okay.
Yep,
Then
when I
what
get
I'm
off
gonna
work,
do is
when I get off that.
okay. Then what I'm gonna do is I'm gonna set aside the judgment and dismiss the case, escrow to plaintiff. You got to make sure you make that payment, okay?
Yeah, I'll drop it off in the money order today as soon as I get off work, Your Honor.
All right, fantastic.
Your Honor, do you need me to prepare that order?
Pardon?
Do you need me to prepare that order for the court?
Please, if you would.
Absolutely, Judge. We'll
appreciate
get that prepped up and submitted.
All right, thank you. Thank you, Mr. Hogan. Have a good weekend.
Thank you, I appreciate you. You too.
All right.
And Your Honor, that's it. That's it for me.
That's it?
That's it.
Okay. Have a great one.
Surprisingly, your docket was a lot shorter than my docket before Judge Barr this morning. That one was
That's right.
very long for the
will
first
hit-
time ever.
Yeah, that will hit me next week though.
Actually, no, we got unfortunately with the new rules, we got quite a few defaults, so there wasn't too many that got rolled over to next week, but a few.
All right. Fantastic.
Thank you, Judge.
You have a great.
You
Thank
too.
you.
Yeah, bye-bye.
Bye.
That's it for that one.
14A stands in recess. Evergreen Apartments versus Lavina Kendricks Haynes.
Good afternoon, Your Honor. Second hearing for plaintiff.
Good afternoon. Hello.
Hello,
What's your name?
Lavinia Kendricks Haynes.
All right. And where are we on this case? This is her motion to set aside.
Yes, I wanted to set aside the eviction because I missed the court date. I thought it was at 2:00 and it was actually at 12 p.m.
Okay.
I worked that day and so I got the days mixed up.
All right. So there are 2 things you have to show. One is that there's good cause for you failing to appear. And then the other is that you have a defense to the plaintiff's claim.
Your Honor, sorry to interrupt, but I believe, so there was a writ entered in this case. Is that correct or no?
Let me look.
Well, in any event, Your Honor, the full judgment amount that was entered was $4,681.61.
Yes.
I understand that so there was 3,000, I think, paid by Hawk. And then there was 1,300 that she had deposited into escrow, I believe, that was released. And then I understand that there's an additional $381.61 that's remaining due on the judgment, which the court confirmed with us was deposited by defendant on the 28th of December. So the judgment may be satisfied.
Yes, 1,300 was sent out. It looks like on December 29th. And then we have $381.61.
Mhm.
So she said judgment.
Yes.
Okay. Well, this will work for you, man. I'll just indicate that the judgment is satisfied.
Okay,
All
thank
right.
you, Your Honor.
You're welcome.
And sorry for being a little messy. Sorry.
No, it's okay.
I'm not used to this. Thank you so much for helping me.
And
Yep.
Your Honor, just for clarification,
Hold on. I'm sorry.
will the court release then the $381.61 to plaintiff?
Yes. Judgment is satisfied and release escrow to plaintiff.
Thank you.
All right. All right. Thank you. Evergreen Apartments versus Desiree France.
Carissa Gazzari appearing for plaintiff.
Hello, what's your name?
Desiree France.
All right. And this is your motion to set aside judgment also.
Yes.
Judgment was entered in the amount of 1948.31 is what I have. And what's your basis for setting this aside?
Okay, so I went to complex to pay, to give the money order. And, because I thought I had to do a cashier's check and stuff like that, but when I got there, they said I had to pay the full balance because January had started, so it was like $3,000 something. And so the writ had already been entered, so I came to the courthouse, but I didn't have it in cash. So I had to, because I had put the name on there, I had to contact money order in order to get the money released. Well, MoneyGram, sorry, MoneyGram. I said money order, MoneyGram.
So just so that I'm clear, you had the 1941.31
On the 2nd, when I went to the complex.
and they didn't take it?
Yes, because she said that I needed to pay the full balance. It needed to be $3,500 and something because January had already started. So they couldn't accept it.
You know anything about that, Ms. Gazzari?
Your Honor, I can find out. I mean, what I understand is that Hawk was going to pay $2,000, but she needed to pay $1,738.85 first. And so I think that the property manager, I understood, encouraged Ms. France to come to the court and deposit her portion into escrow so that we could square away the full amount.
And that's what. And the only thing I'm waiting on is for them to release the money, because once you put the name on there, I couldn't cash it as in my own name anymore because it was addressed to the apartment complex.
How long are they going to say they're going to take that?
They said 10 to 12 days.
And when did you send it back to them?
I sent it on the 4th. No, the 5th, sorry, the 5th.
Of this month?
Yes.
So it should, I'll tell you what I'm going to do. Let me adjourn this out 1 week.
Okay.
Okay. When you get the money, then you need to put it in the court escrow.
Court escrow? Okay.
Yes. Okay, so you got to have cash.
Okay. And the money is higher because Hawk said that they would pay the 2,000.
Yes, ma'am.
And I had to pay the rest, but it was only supposed to be 15. It was supposed to be 1519. So I was a little confused on the 17 you're stating right now.
Okay, let me look at what the balance is. And can we also confirm from Amy that Hawk is paying the 2,000?
They said as long as I had the, sorry.
Amy?
Good afternoon, Your Honor. So she did have her intake on the 4th with Alicia, and looks like they are wanting to help is just whatever the portion is above that threshold.
That she needs to pay.
Correct.
And,
Okay.
and Your Honor, I show the current balance is $3,738.85. So if Hawk is paying $2,000 and Miss France pays $1,738.85, we would be satisfied.
Okay. Because it must
Think
have
you'll
been,
be able to do that?
I can't, I'll try to get that, but
Okay. We can work out the math later. You just got to get this in so Hawk can pay that.
okay.
Okay. So I'll adjourn this matter to January 19th, 2024
Okay.
at 9 a.m.
I'll have to appear here.
Yes, ma'am.
Okay.
All right.
Right. Thank you.
Thank you.
Your Honor.
Thank you. Have a great weekend.
Thank you, you too.